everyone, today we will do legal dictation for High Court and Civil Court exercise number 12. You can get the PDF from description box. So ready? Start. Ascertainment whether allegations in pleadings are admitted or denied. At the first hearing of the suit, the court shall ascertain from each party or his pleader whether he admits or denies such allegations of facts as are made in the plaint or written statement, if any, of the opposite party, and as are not expressly or by necessary implication admitted or denied by the party against whom they are made. The court shall record such admissions and denial. Oral examination of party or companion of party. At the first hearing of the suit, the court shall, with a view to elucidating matters in controversy in the suit, examine orally such of the parties to the suit appearing in person or present in court as it deems fit, and may orally examine any person able to answer any material question relating to the suit by whom any party appearing in person or present in court or his pleader is accompanied. At any subsequent hearing, the court may orally examine any party appearing in person or present in court or any person able to answer any material question relating to the suit by whom such party or his pleader is accompanied. The court, if it thinks fit, put in the course of an examination under this rule question suggested by either party. Substance of examination to be written. The substance of examination shall be reduced to writing by the judge and shall form part of the record. Rule 1 enables the court to ascertain from each of the parties or his pleader at the first hearing whether he admits or denies such of those allegations of fact made in the pleadings of the other party which were not expressly or by necessary implication admitted or denied by him. In other words, if the defendant in his written statement fails to expressly or by necessary implication admit or deny any of the plaint allegations, the court can ascertain from the defendant whether he admits or denies the said plaint allegations. Similarly, if the defendant has made some allegations against the plaintiff in his written statement and no reply is filed thereto by the plaintiff, the court can ascertain whether plaintiff admits or denies those allegations. Resort to Rule 1 of Order 10 is necessary only in cases where the court finds that the plaintiff or the defendant has failed or implicitly admit or deny any of the allegation made against him by the other party. Examination under Order 10 Rule 1 of the Code will not be necessary where the pleadings of each party have been fully and clearly traversed by the other party. On the other hand, the examination under Rule 2 of Order 10 of the Code need not be restricted to allegations in the pleadings to the other party, but can relate to elucidating any matter in controversy in the suit. Further, under Rule 1 of Order 10, the court can examine only the parties and their advocates, that too at the first hearing. On the other hand, Rule 2 enables the court to examine not only any party but also any person accompanying either party or his pleader to obtain answer to any material question relating to the suit, either at the first hearing or subsequent hearing. The object of oral examination under Rule 2 of Order 10 is to ascertain the matters in controversy in suit and not to record evidence or to secure admission. The statement made by a party in an examination under Rule 2 is not under oath, and it is not intended to be a substitute for a regular examination under oath under Order 18 of the Code. It is intended to elucidate what is obscure and vague in the pleadings. In other words, while the purpose of an examination under Rule 1 is to clarify the stand of a party in regard to the allegation made against him in the pleadings of the other party, the purpose of the oral examination under Rule 2 is mainly to elucidate the allegation even in his own pleadings or any documents filed with the pleadings. The power under Order 10, Rule 2 of the Code cannot be converted into a process of selective cross-examination by the court before the party has an opportunity to put forth his case at the trial. The above position of law is well settled. We need to refer only to decide